week's Ask an Atheist. My name is Sam Grover, and I'm Associate Counsel for the Freedom From Religion Foundation.
And I'm Patrick Elliott, Senior Counsel at FFRF. And today, Sam and I are going to be discussing the Supreme Court's recent case on a high school football coach's prayer practice.
As always, if you have questions about our topic today, you can drop them in the comments below or send an email to askanatheist@ffrf.org. Patrick, you have worked on the case we are talking about today, and you filed the Amicus brief on behalf of FFRF to the court. Can you give our viewers some background on the lawsuit?
Sure. This starts in 2015 with Coach Joseph Kennedy, who is an assistant football coach in the Bremerton School District, which is a school system in Washington. He had been engaging in prayers with the students on the team, including in the locker room. And then after games, he started a practice of having a prayer on the 50-yard line, both with the players from his team and players from opposing teams. When the school district found out about that, they eventually told him to stop. So this happened in, let's say, September of 2015. He didn't agree with that. He said that his religion required him to do these prayers on the 50-yard line. His attorneys and the school district had a back and forth. And basically, they said, well, we can accommodate you to have a prayer, a private prayer on your own, but we're not going to allow you to do this kind of public prayer that you've been doing with students from your team and from other teams. He didn't agree to that, so they ultimately suspended him and then didn't renew his contract. He sued and brought forward both a free exercise claim under the First Amendment and a free speech claim. He lost in the district court, and then more recently he lost before the U.S. Court of Appeals for the Ninth Circuit. He petitioned the Supreme Court with this conservative court. They agreed to take that case up under both claims, both the free speech and free exercise. And so that's where we are today. The court's now heard that case. They had arguments on Monday, which hopefully you and I can dissect a little bit.
Yeah. That's why we're here today as two of FFRF's attorneys to sort of dive into what the justices were keyed into during oral argument. And one of the key facts in the case seems to relate to whether the prayers were private and personal, as the coach describes them, or whether it was really a communal prayer. Now, early on, as you said, Kennedy was making it seem like it was a group activity. And we have a Fox News clip from 2015 that discusses that.
A number of years ago, you started, after the game, you would just walk to the 50 all by yourself, and you started praying. And after a couple of games, some of the players realized what you're doing, and they joined you. And what has it become since then?
It's actually become quite a interesting thing. It's really incredible to see that the whole entire team coming out there and, joining us, just voluntarily want to join everybody out there. And then it's spread through from there to the other teams. And now everybody in the league, we've had the opposing team, doesn't matter if it's a home or away game, they have joined us out on the 50
that's great.
For the whole thing.
Sure.
And so you could see, at that time, he was really talking about this as a communal, as a team event. If you fast forward to today, the briefing before the court, and even some of the argument before the court, this was really pitched as being, private or personal prayer, which I don't think, knowing the history and knowing the context, that was really the case at all, Sam.
Yeah. So it seems to me that when you have the coach doing this, and then you have his players starting to dive in and do it with him, that's the coach leading that and directing it. And that's why it happened in the first place, and why it continued.
Yeah, and he kind of focused in on the word voluntary, and I think this has been a theme that they've said, oh, this is just voluntary. But, when coach starts something, players are definitely going to want to participate in that and are going to want to continue with whatever the coach is doing at that time. So I think that word isn't really true in a true sense of the word. The practices of the coach become the practices of the team, really.
Yeah, well put. The coach, at all levels of sport, but especially when it comes to student athletes, the coach is the leader, right? The coach is the one who dictates what the sorts of the traditions of the team are and the practices of the team. And so this is Coach Kennedy saying, yeah, we're a team that's going to pray at the 50-yard line after games.
Yeah, and that's so we filed a friend of the court brief with the Supreme Court in this case on behalf of the Freedom from Religion Foundation and several other secular groups. And that's really what we highlighted, and I was pleased to hear some of the justices key into that as well. So we have a clip of Justice Kagan, asking about some of these same issues.
I mean, really, why? Why can the school discipline him? And I'm going to just sort of suggest and find out whether you agree that if you look at our prayer cases, the idea of why the school can discipline him is that puts a kind of undue pressure, a kind of coercion on students to participate in religious activities when they may not wish to, when their religion is different or when they have no religion. Is that correct?
So, look, I think it's simpler than that, quite frankly.
I think a lot of this Garcetti stuff is just not getting to the heart of what we care about, what our cases have long cared about in thinking about these questions, which is coercion on students and having students feel that they have to join religious activities that they do not wish to join, that their parents do not wish them to join.
Right, so that's well put by Justice Kagan, and it really drives home the main feature here, which is in reality, when your coach asks you to do something or suggests that something will gain your favor or his favor, that's something that student athletes are going to take notice of, right? They want the coach to like them because the coach is the one dictating things like their playing time on the team and whether they make the team.
Yeah, and I kind of appreciated this question because it was a little bit of the higher level approach. Are we concerned about, on the coach's side, his religious liberty, or is the kind of underlining principles involved here, the vulnerable people, the players, there's concern that their religious liberty is going to be violated, that they'll feel compelled to participate in some religious activity that they would choose not to, or their parents would choose not to. So I do appreciate kind of the higher level discussion, which is obviously what we've highlighted with the school district's concern is highlighted. That you had some of the justices really talking about that, I think is definitely helpful, and not just from the perspective of Coach Kennedy. We've seen this, Sam, as you'll recall, in the Masterpiece Cake Shop case, the case of a baker saying he couldn't bake a wedding cake for a gay couple. Whose liberty is at interest, or whose rights are at interest? Are you looking at it from the lens of the people who are denied a public service, or are you looking at it from the lens of the person who's refusing to provide it? And here I think at least we have some counterbalance, or more in the forefront, a counterbalance of the rights of students are at least being discussed in this context.
Yeah, a lot of the media reporting I've seen on this case has fallen into this trap where because the case is Kennedy v. Bremerton School District, they focus on the one face there, and that's of Kennedy. But there are so many other faces that aren't being shown, and that's all of the players, all of the parents, and their right to dictate the religious or non-religious upbringing of their students. There's just a host of kids and adults being affected by Kennedy's choice to wrap up the team in his individual prayers. Some of the justices wanted to get more into the particular facts in this case to really hone in on that. And what we have next is a clip of Justice Sotomayor asking Joseph Kennedy's attorney about some of those facts.
What do I do with the facts that parents complain that their children wouldn't follow their directives, not because they wanted to pray, but because they felt pressure to pray? What do I do with the fact that when the coach was, the school explicitly said, students don't have to come if they don't want. Many of them didn't. Some still did, but many of them didn't. And what do we do with the fact that a coach from another team was the one who brought this to the school's attention? Because your client – asked him and his players to join in the prayers. Don't those facts suggest the very coercion that Justice Kagan was talking about?
Yeah, so coercion is the name of the game here. And those facts speak for themselves. Kennedy is inviting coaches from other teams and all their players to join in. He's talking to his players, and his players are joining in because of that. In reality, there's no escaping that Kennedy's making this a point on the team, that he's making this a cultural point for the team.
Yeah, and I wanted to get your broader take. I guess this kind of brings to mind much of the focus, at least so far, that we've heard from some of the clips, and I think this was true of the nearly 2-hour argument. So thankfully for you all, we've kind of picked a few things to talk about. But really the focus was on coercion and that aspect, and not some of the other issues that you often see with religion in schools or establishment clause. Sam, so I'm just kind of curious on, I mean, it seems that the court has honed into that. Maybe that's because there could be a consensus of even, let's say, 6 or more justices that would agree that coercion is the test for schools. Just generally, I guess I'm curious what your take is on the legal tests and that being discussed, coercion being the focus here, not some other aspects.
Yeah, that was a point that Kennedy's attorneys really emphasized during the oral argument, was that it's coercion here that matters, and they're advocating for the Supreme Court to use this case as the case to overturn the Lemon test and the endorsement test as well, which are the traditional tests that focus on what the Establishment Clause is meant to protect, which is you can't have the government endorsing religion and promoting it to people, which Kennedy's prayers are clearly doing here. And you can't undertake government activity with the purpose of advancing religion, which, again, when Kennedy is in the locker room talking to his team about his personal religious beliefs, yeah, that's undertaken for the purpose of indoctrinating his players in his personal religious views, whether the players like it or not, and whether their parents like it or not. So this practice violates all of those aspects. It violates the Lemon test and violates the endorsement test before you even get to coercion. But Kennedy's lawyers are saying, hey, this would be the case where you can finally say that those other things don't matter, and that it's only coercion that matters.
Yeah, what's a little troubling about that too is, this Lemon is getting attacked. If people have heard that phrase before, even if you know a minimum amount of the Establishment Clause, you may have heard Lemon test. But really, that was a synthesis of several prior decades of cases, going back to the earliest school prayer cases where the court said, we're going to look at, what's your purpose? Are you trying to do something religious? And then what are the effects of that? Are you actually advancing religion? And then the third piece of it is there entanglement? Is there some involvement between the religious entities and the government that is really disturbing to us? That's just a summary of the prior law. So what's troubling, if this case is the vehicle to do this, is to get rid of all of that. It's really, going back to the 1960s, really would be undermined. All of those cases that deal with religion, most of them deal with religion in schools, Bible readings in schools, prayer in schools. I don't even think this Supreme Court thinks that those are permissible, but that's really what the Lemon test was enshrining, was just this prior principles of, promoting religion in some way. And they're using terms that maybe people don't agree with today, saying endorsement. The court doesn't seem, or some of the conservative justices don't seem to like that term, but I think the principle is sound. It really is something that encompasses what the First Amendment means. We don't think the government should take sides on controversial religious questions. I think that shouldn't be as controversial as they seem to be making it out to be.
Yeah, and make no mistake, if they get their wish and the court does do away with religious purpose, religious effect, and endorsement as things that we care about when we talk about the Establishment Clause, if they hone in just on coercion, well, in this case, the justices are sort of accepting that there are some sorts of subtle coercive pressures at play when it comes to a high school coach and student athletes. But moving forward, if coercion is the only test, well, then outside of the public school context, the other side is going to be advocating that coercion doesn't apply if it's just done subtly. They're going to be saying it's only when there's strict legal coercion that the Establishment Clause is violated. They're going to be saying, unless you have to pay money or go to jail for not participating, well then, grown-ups aren't subject to those kinds of pressures.
Right. And I think it's contrary to kind of a historical view of what the Establishment Clause meant. It wasn't only concerned about coercion. It was concerned about abuse of the government being involved with religion. So certainly I think it's contrary to, pretty typical interpretations of the Establishment Clause and the meaning of the First Amendment. And I actually think a lot of the conservatives might not like the end result of this, because you may see communities that maybe have a more progressive religious view adopt that as doctrine, which might well upset some of the conservatives, depending on what their religious beliefs are, in reference to any number of things, including controversies that we see today on things like gay marriage, respect for LGBTQ Americans. I mean, there's any number of things where the government could be involved in and say, hey, it's not coercive, that would be permissible. So I say a little bit, be careful what you wish for from this court or from the other side, because we don't want the government and religion to be interacting to a great extent. They're about to, maybe unleash a little bit more of that, and I don't think you can predict it's going to go the way that they necessarily think it would.
Yeah, I think the sort of natural extension of doing away with endorsement and religious purpose as things we care about is that the government becomes free to do so much, at least when it's targeted at adults, right? Like under the strict coercion test that Kennedy's attorneys are ultimately in favor of, what's to stop the government from putting up billboards that say, go to church on Sunday, right? Like that's not coercive in the strict sense that they think the coercion test cares about.
Right. It definitely, and especially on the financial side, it would cause a problem about government spending in favor of religion, which has already been undercut by some of the court's rulings on standing and other things. We've been talking about this coercion thing. I would say, thankfully, some of the conservatives seem to agree with us, at least by their questions. I don't know what their opinions would look like. And as an example of that, you have Justice Kavanaugh asking a little bit about this, the particular context of the coach and the student. So we have a clip of Justice Kavanaugh talking about coaches.
What about the player who thinks, if I don't participate in this, I won't start next week? Or the player who thinks, if I do participate in this, I will start next week, and the player's wants to start?
So that's where I think making a clear message that that's inappropriate, that this doesn't matter for those purposes, that's how you deal with those problems. And if there is a coach or a teacher,
how will you ferret that out? Because every player is trying to get on the good side of the coach, and every parent is worried about the coach exercising favoritism in terms of the starting lineup, playing time, recommendations for colleges, et cetera.
I think the school district, if it has that concern, and I'm not saying it's not a legitimate concern, just makes it as clear that it's school policy, that nothing turns on that.
Yeah, this is one of those rare instances where Justice Kavanaugh seems to get it. And that probably in part comes from his own experience being a student athlete, right? This is the Supreme Court is made up of people who come from very from positions of power in almost everything that they do, right? Certainly when it comes to their jobs and the court clerks they work with, they're the ones exercising subtle coercive pressures on the people they interact with. Certainly during oral arguments, right? When they speak, the attorneys stop, right? But Kavanaugh here seems to understand that when it comes to coaches, they exert that sort of pressure over players, and so maybe he experienced some of that when he was a student athlete. I don't know for sure. I'm speculating, but his question seems to accept that that is the reality.
Yeah, and I think the language used, I think he said, ferret that out. So I think he kind of gets to that, especially in the coaching context. It's not the same as maybe a teacher grading a paper or something where you might at least have some rubric or objective criteria. these are very discretionary decisions on who's on what team, what playing time do you get, what position do you play, what plays are called. These are things we kind of talked about in our brief. Just the nature of the job is people are making some of those calls. So I don't think the answer from the Kennedy's attorney here, which is a very experienced litigator, Paul Clement, former Solicitor General, are that convincing. He kind of thinks, oh, well, everybody's trying to curry favor with the coach, but there are some things that are impermissible in terms of currying favor with the coach. We don't disagree that the coach couldn't make decisions based on, race or national origin or something like that. Why could the coach do it on religion? Obviously, they can't. The coach might be able to do that on some other basis if the person's just, sucking up to the coach and trying to say, I like the same NFL team that you do, if it's the Green Bay Packers or the Patriots or whoever. That was part of his response. I don't know if we got the full clip there, but I think Kavanaugh's question is getting at that problem, is both people are going to want to please the coach, and also we might not really be able to tell why the coach is making some of their decisions. And so how do we protect students from that type of favoritism or discrimination?
Right. And Clement's answer there sort of puts it back on the school district. Like, oh, well, the coach can do what he wants, but it's the school district's responsibility to make it clear to the athletes that, nothing actually rides on whether they participate in these prayers. That's a nonsense answer, right? Because, you can have the principal or the superintendent telling the students one thing, but when they're interacting with this coach every day in practice and before games, it's what the coach says that matters. It's what the coach does over and over that the students are going to pick up on, and they're going to react to that.
Yeah, I think you've nailed you've nailed a lot of it. I don't think that was a convincing answer, as much as the conservative justices seem to be on Coach Kennedy's side. I think that was kind of the take from a lot of the media who watched that argument, and even just taking this case in general. But the fact that we have some support, at least questioning of that, some of these principles, is helpful. I think that you have Kavanaugh here, some of the other justices asking some other questions that were interesting. This argument was a little bit, I wouldn't say necessarily all over the place, but both kind of the facts, the law, and that you had these two separate issues, the free speech and the free speech and the free exercise. It was a very long and kind of broad argument. I know there's one point that you also wanted to talk about that I thought was kind of a unique point in the argument.
Yeah. So the justices seemed to be all over the place in terms of what they were asking about. They all had their individual line of questioning, which is odd for these sorts of arguments. Usually, you end up with multiple justices asking the same sort of question in different ways, or coming up with their own hypotheticals, and there certainly were a lot of those. But there were also some really out there questions that I couldn't really get a grasp on what the point was. So one of those that stuck out for me was Justice Barrett asking about talking to a god. Here's the clip.
This is, as Justice Thomas asked you at the beginning, both the free exercise and free speech claim. Who is he communicating to? God? Like, where's the speech?
I think he is communicating to God.
And so that would trigger the First Amendment protection.
Under both the free speech clause and the free exercise clause.
Well, I understand the free exercise part of it, but even if he's not communicating to an audience, so he's completely silent, he just takes the knee, that's protected speech, even if he's not trying to communicate to anyone around him, just to the Almighty.
Absolutely. It's expressive conduct, or speech.
Yeah. So I guess I'll just put it to you, Patrick. What nefarious purpose is Justice Barrett driving at ultimately when she's talking about whether communicating with God counts as expressive speech?
Yeah, I don't think it's clear where she's going with this. And there may be different interpretations or reasons for asking it. I think one reason, which it actually might be somewhat on our side as to the free speech issue, is I think she asked, she's asking if he's communicating to others, or is he just communicating to God? So, he may not have a free speech claim if he's saying, I'm not sending out a communication to those in the audience, right? If he says that, you may not have a free speech claim. If he admits, I'm speaking to all the other people in the area because I'm signaling to them that I'm very pious, I love prayer and prayer is great, well, then that kind of is in line with what the school district's concern is. Like, hey, this guy's trying to tell all the students prayer is great. You should all pray. I'm praying. Look at me pray. So I don't know. And maybe because she kind of, Justice Barrett comes from an academic background, it almost seems like an academic question. It's like, who are you communicating with? And maybe I need to think of, is this really a free speech question, or is this more of the free exercise question? So I don't know if you have a separate view on it. I don't have an answer to what this was really going for.
Yeah, I think my view on it is just that the facts as laid out in the case really don't support the idea that this is like a private prayer moment, right? This is, they talk about it in the arguments as like, this is Kennedy's way of celebrating after the game, right? And players celebrate all the time at the 50-yard line or the end zone, and this is, Kennedy's way of doing that. But all celebrations are performative, right? They're all meant to express elation or happiness with your teammates. They're all communicating a message, and it's extremely clear based on the history of Kennedy's conduct here that he has always intended this to be a public display, right? There's no reason for him to walk to the 50-yard line except to draw attention to himself.
Yeah, I think the location is central to that. The 50-yard line is where, if you watch football, there's a lot that happens there. There's, sometimes post-game handshakes. You have the ceremonial coin toss, depending on the level of play. That's a place that carries significance. Sometimes if you watch a game, it's very insulting to do something on somebody else's 50-yard line. So he's chosen this place, especially given that he was given the opportunity to do a prayer in another location. Let's say out of the middle of the field, in the press box, this was offered to him, inside the school. He declined all of those, and he specifically picked a place that was very prominent and then invited people to join him. He invited the local community to come on the field. So I think the school district's concern that this was performative or communicating to all those there is definitely on target.
Yeah. All right. So moving away from the actual oral argument, let's discuss our arguments, the arguments that you made in FFRF's amicus brief to the Supreme Court. So specifically, can you tell us, well, the title here of our talk is "The Supreme Court Drops the Ball on Prayer," right? And we love a good pun, but it's more than that here, right? The Supreme Court is actually blowing it by even holding these oral arguments, right? Can you tell us why the court never should have taken this case, and why even now it should be dismissed?
Yeah, and this is maybe beyond some of the scope of what our viewers would pay attention to, but as lawyers, we pay attention to this kind of thing, is who can sue and who still has the ability to sue. This all happened in 2015 after Coach Kennedy lost the case in the district court in, I think it was 2020, and had appealed to the Ninth Circuit. He moved about 2,800 miles from the Bremerton, Washington area to Pensacola, Florida, and sold his house, bought a new house, no longer is employed in Washington. I don't know if he's employed in Florida, but he picked up and left. And so one of the problems, at least from our perspective, is, hey, this was an Establishment Clause plaintiff. There's no way the court would say, we have the ability to rule on this case. The case became moot once the person has left the geographic area and is no longer able to really challenge, the policies of a school district in Washington as a Florida resident. That's very hard to do. So the school district filed a brief saying, hey, we think this case became moot. We just learned about a lot of this. They didn't know that initially. This was all kind of after the Supreme Court already agreed to take the case. And so we pointed out, yeah, this case is moot. Somebody who's no longer in that community can't challenge this type of thing. And by the way, the Supreme Court, this is what you've done in all of the other Establishment Clause plaintiffs when it's, religious minorities or the atheists who are suing. You've made it very difficult to maintain a case once the person leaves. And that often happens with students who leave a school district because they graduated or otherwise. Sometimes people are challenging employment practices in state government and then they move. So there's a lot of case law saying you can't do this anymore. Disappointingly, the Supreme Court didn't ask any questions about that. I think that, maybe there'd be a hint that they'd be looking at it if somebody asked a single question. But that is kind of an underlying issue, is whether this case became moot after he totally left the area. The court could still rule on that aspect of the case. And the second thing we argued is just, hey, this is really problematic for the non-religious students and for religious minorities because of some of these issues we've talked about. They're going to please their coach. And we pointed out examples from either our cases or known to the public when people suffered the consequences of not praying with their coaches or teams or generally in school, or have even challenged those things. They kind of get run out of town and they really get vilified in the community. And that's something that the Supreme Court has to be concerned about, is coercion and people being pressured to participate. So that's the two aspects of our brief that we wrote about.
Yeah, just going back to the who can sue question, it really is it's a question of whether all people are going to have equal access to our justice system, right? If courts are picking and choosing when to bring up standing to sue, whether to even question whether a plaintiff has the right to sue, if courts aren't doing that consistently and applying it equally across the board, regardless of whether it's a Christian or a religious minority or an atheist, then that's an issue of equal access to the courts. And if the courts aren't held to that equality standard, then you're going to get these activist courts only weighing in favor of one side of an issue over and over again, and the other side doesn't get a chance to speak or fight back.
Yeah, and we'll see how the court, deals with this. We expect an opinion will come down by the end of June, maybe the very beginning of July, but certainly we're going to get an answer, and hopefully the court will at least discuss that aspect, so that this principle, who can sue, at least will be applied equally to people on both sides. I think it's a good time to go to some of the questions. We do have questions coming in. If you have those, enter those below this video, and hopefully we can get to some of these. And you can do that posting on Facebook or emailing askanatheist@ffrf.org. We've got a few already, so I will start with those, and Sam, I'll read them to you, and hopefully you can take first crack. Sarah Lewis asked, is coach-led prayer a really common complaint you get at FFRF? How often do you get the schools to stop versus how often do the schools ignore you?
Yeah, it is a common complaint that we get. There's a culture, especially in the South, of really wrapping football and religion or sports and religion together. And by religion, I almost always mean Christianity. So yeah, coaches do this a lot. They're trying to build the character of student athletes, and while that's like a laudable goal, they can't incorporate religion into it. They can't be promoting their personal religious beliefs as a valuable character trait. So we do receive a lot of these complaints, and when we write to these school districts, we're almost always successful in getting those stopped, because the law is actually crystal clear that in public schools, teachers and coaches can't be pushing prayer on students.
And one of the interesting things about where the complaints come from on this is a really big football problem. There are schools that have all sorts of different athletic programs, all sorts of different team and individualized sports. We get this in football a lot. And as I was doing some research for our brief, I actually found there was a study that sent out surveys to athletic directors in some of the southern states. And it seemed that study confirmed that really a lot of the football programs in these southern states had prayer. We hear about it. We usually are able to resolve it. But I thought that's an interesting aspect, that this case is the typical thing that we see, that football coaches are doing prayers with their teams. We're not seeing that very often with coaches, tennis coaches, or other kinds of coaches. It's a football problem.
Yeah, well put. And the problem persists on into college as well, and probably on professional teams as well. But when it comes to state schools, FFRF has published our Pray to Play report, which talks about specific problem coaches at the college level.
All right, we've got a question from D. Hamilton. How can his lawyers say that when he prays, he is no longer officially a coach at that time, but a private citizen exercising his rights?
Yeah, this is a question. It's a timing question that came up during the oral arguments through a series of hypotheticals about, if a teacher is, reading a Bible before the bell rings, is that okay? Versus at the end of class when the teacher's supposed to be, talking to students as they leave the room, if the teacher's, doing a silent prayer, then is that okay? These hypotheticals came up. They're really trying to do some interesting line drawing about, when is an employee on duty. And I think when it comes to the coach, those hypos are mostly irrelevant. The coach is doing this, before he's off the field, right? He's there. The players are still there. He's going to go talk to the players and their parents right after he does this 50-yard line prayer. I mean, you can speak more to the facts, Patrick. You're pretty well versed in them, but my read on it is, as soon as the end of the game happens, as soon as the clock hits 0, he doesn't stop being a coach, and the players don't stop caring about what he thinks and what he's doing.
Yeah, I think where this kind of gets I guess it's easier to talk about the easy case. Person who's employed by a school system who on Sunday goes to their own church and is doing Bible readings. No dispute that person's exercising their private rights. School has no interest in regulating their conduct or doing anything. The same could be said for a teacher who, leaves school and does something on their own time. This is what we're talking about here is on the football field immediately after games where coaches still have responsibilities for those students. So I don't think that was really in dispute, that he was still basically on the clock and that he was still responsible for students under his care. The way that his attorneys kind of talked about this was, well, he could make a private phone call at this time. He could do any number of things. Therefore, he can do a big, a showy prayer. So that's how they were trying to liken it, which I think might actually lead to some chaos in the school environment and you had some justices talk about this. Well, what if coaches want to do some kind of political statement right at this time? Would that be permitted? And if the idea is that, Kennedy has a free speech right to do this, then I think schools are going to be in for a wake-up call that their coaches and their teachers are going to be allowed to do all sorts of things that the school might say, hey, we don't think you should go out on the field and unfurl a big political banner saying vote for so-and-so on the, right after the game. You think a school could tell their coach to not do that. That might be circumscribed if the idea is, well, coaches, as long as they could do something else private, like a phone call or do some other activity, therefore, they're now, they can do whatever they want. So that's kind of why the private versus public aspect comes up is there's some clear cases, and then this is a case where they're trying to kind of muddy the waters on what coaches can do.
Yeah, and then when it comes to the question of whether this is a coercive practice, there was a question during the oral argument about whether the public versus private thing even mattered, right? If you have the coach coercing participation in the prayers as a private citizen or while he's on the clock, it shouldn't matter. Coercion continues to be coercion.
Yeah, I don't think you have to get into the detailed analysis in those instances. Okay, we've got a couple more here. Ann Bendixson asked, were there any surprises on Monday? Other than searching through SCOTUS filings, is there a place to go to find a concise list of the organization that filed amicus briefs? And also, if SCOTUS makes a limited decision on this case, are there other cases they could take to further weaken state-church separation? So few different issues here. I can answer the administrative one, Sam, before I push it to you. Where can you get info on, the organizations that filed briefs? What did their briefs say? Thankfully, the Supreme Court has a very good website. You can look up, if you search Bremerton on their case docket, this case will come up. You can find all of the briefs. SCOTUS blog is also a great resource for finding all of the case information. There were a lot of briefs on both sides. Some of the briefs on the Bremerton School District side were quite surprising. You had former NFL players. You had some people in the community saying how divisive this was. You had some clergy filing briefs, historians. So really a good coalition on our side on this, on this brief. So that's one thing you can look for. But I guess, Sam, the question about are there any surprises, and then other cases that they could take to kind of weaken state-church separation?
In terms of surprises, I think just how boldly Clement, the attorney for Kennedy, was just advocating to overthrow Lemon and endorsement was surprising. He basically just said, do it. And that kind of advocacy, rather than actually taking on those, rather than addressing those tests and how the facts would be applied under them, he basically he dismissed them as irrelevant. I thought that was a little bit surprising. Did you have any surprises, Patrick?
No, I mean, it's kind of what we thought. I think I was surprised that coercion is agreed to be a problem in the school context with this court. But there seems to be a wide agreement to just get rid of this state church protection. And it's not so much a surprise, but a real shock to being, a concern for what might come. And I think this question about what other state church cases might make it up there, I don't know. You could have employees in school districts really take this and try to run with it. And so it might take several years before we get the next case like this. But this is step one. I don't know what step 2 and step 3 are going to look like for the religious right in pushing this kind of thing.
Yeah. The other thing, when it comes to other cases, a common reaction we get from the public when they see a Christian government official getting away with something is the public will say, "Oh, yeah, well, look out, because now the Satanists or the Muslim football coach is going to get to do this too." But that's not how it works in practice, right? The Supreme Court, especially when they disproportionately care about standing and aren't applying that evenly across the board, the Supreme Court's not going to hear that case. They're going to dismiss it on their shadow docket, and they're only going to take cases that advance their desired narrative, which is that Christians are being persecuted in some way, and that we need to have more religious freedom, at least when it comes to Christian government officials.
Yeah, I agree with that. And we have a comment, and I'll read it, though, because normally, this is for questions, but this is a helpful comment, I think, reinforcing kind of what we talked about. Kimberly DeMarc comments, "My son's football coach was constantly pushing religion, praying and having the players meet at his church to worship. My son didn't want to go, so he was left out." And I really think that kind of reinforces some of what we're talking about. For this particular parent or others, you can contact FFRF on these issues. You can report a violation at ffrf.org/report. So keep that in mind. If this is a situation where the coach is still operating and doing this kind of thing, we try to work on behalf of parents. We can help shield their identity so that any player isn't known to be the one bringing the complaint, because obviously they would be concerned about having that be known. But I think this comment from Kimberly is similar to what you and I, Sam, have seen many parents complain about, is that this is something that football coaches are doing, and parents are not always aware of how to push back on it or how to respond to it.
Yeah, it's certainly a problem in the football context. It's also a problem just with teachers in the public schools generally. They seek out ways, not all public school teachers by any means, but we hear a lot of complaints about specific teachers who are seeking out ways to advance their personal religious values, not just in a general way, but specifically to promote their religious practice to their students. So
all right,
contact us.
A final question here from Becky Brooks. "I wonder if people would be okay if the coach prayed to a different God than their own God in front of their kids."
Yeah, I think that goes to what I was saying before. No, they wouldn't be okay with it. You don't see it happen because if you are so lucky to be a religious minority football coach in the South, where the coach-led prayers are a fairly common practice, you're going to keep your head down, right? Because there will be community backlash if you go about flaunting your non-Christian beliefs or your non-belief if you're an atheist coach. That doesn't happen because that's not a way to continue having a job. So
yeah, I think that's it for questions. We'll have to just watch for this opinion coming out again by the end of June. Sam and I maybe will have to do a follow-up at some point and kind of dissect what the court actually does with this case.
Yeah, the court is primed to do away with some Establishment Clause protections in a number of cases, and Patrick and I would love to come on and discuss how the wall between church and state is crumbling as that comes up. So that concludes Ask an Atheist for this week. Thank you for joining us, and be sure to check out FFRF's broadcast TV program, Free Thought Matters. This week, Dan Barker and Annie Laurie Gaylor will be speaking to Amanda Tyler, who's the executive director of the Baptist Joint Committee for Religious Freedom. Along with FFRF, she helped publish a report exposing the white Christian nationalist roots of the January 6th insurrection. Here's a preview.
Christian nationalism heavily relies on this false narrative of the United States being found as a quote-unquote Christian nation. Of course, the United States was also founded on the institution of slavery and race-based segregation and all of the horrors that go along with that. And so to say that God had some kind of providential role for the United States in that history also suggests that God would endorse slavery, that God would endorse segregation, and these kinds of deeply embedded narratives that often are very difficult to unseat. This is part of white Christian nationalism.
Yeah, well put. You can watch Free Thought Matters on TV stations around the U.S. on Sunday mornings or on FFRF's YouTube and Facebook channels.
Radio show and podcast. Our guest this week is a Reverend 92-year-old illustrator and artist Ed Sorrell, who just released a retrospective of his life's work called Profusely Illustrated. To find out where to hear Free Thought Radio, visit ffrf.org/radio.
And if you want more information about the Freedom from Religion Foundation, check out our website at ffrf.org. See you next time on FFRF's Ask an Atheist.